May it please the court, counsel. I'm Ron Smith. I represent Bruce Wyandt in this case, and I would ask that I get 5 minutes for rebuttal.
Sure.
Background of this case, which is clearly in the briefs, is that my client owns and runs a tattoo shop in Pinellas Park. It's in a strip center, and at the time of this incident that's complained about, the petitioner was the manager of an electronic cigarette shop.
Mr. Smith, can I ask you just a procedure question? I checked recently. Did anybody submit the video yet? I thought we asked somebody to submit the video. Okay.
I don't know. I know that the video, I might have it, but the video, it doesn't have any sound on it.
That's what I understand. Well, okay, that's neither here nor there, but I know I recall we sent an order out asking for somebody to supplement the record with the death surveillance tape.
I didn't get any information as to supplement the record, Your Honor.
All right.
I can probably find it either in my file or when I get back. But
All right.
I thought it would have gone along.
If we really need it, we'll ask for it again.
Pardon?
If we really need it, we'll ask for it again.
Okay. In any event, a problem arose with the parking that was involved with the two shops, one at one end and one at the other end of the plaza. The manager of the strip center got involved. He got involved a number of times, and he wound up giving my client, assigning 2 parking places specifically for my client's business. The police were also involved on a number of occasions, and they came down at the request of actually both parties on separate occasions, and no arrests were
I don't have any
made.
vision about how long this strip mall is. Are these stores within 3 or 4 doors of one another, or 20 doors, or?
It's, I'd say probably about, it's 4 or 5 doors between each other. I don't think it's more than a couple hundred feet.
Okay.
The entire strip center.
Okay,
I'm not good at measurements.
that's all right.
In any event, the problems arose with the parking. The police were called. There were never any arrests made for either a stalking, assault, or any batteries that occurred between the 2 parties. This case boils down to 2 incidents, which was outlined in the record when I cross-examined the petitioner therein. The first incident was on the 18th of, I believe it was June, when the petitioner wound up coming into her store as she was, after she parked her car, she's got out of her car, she's coming into the store. There's a number of people in the parking lot, including my client and other people. They're sitting there, I believe, under a tree smoking real cigarettes as opposed to the electronic cigarettes. But in any event, there was some statements made by members of the group that my client was with that called this girl, Lisa Voccio, a number of unsavory names. And there was some incident there that was not attributed to my client, and I specifically cross-examined Ms. Voccio below on that, and she specifically said that my client didn't say these things. But there was somebody, I believe the judge made a ruling that she felt offended, the court felt offended below, that some from a party would say, "Come and sit on my face," type of, vulgar things. That's one incident that occurred. That was one incident that they relied upon for the stalking injunction. The second incident was on the 19th, the very next day. Cars were parked at my client's parking place. My client went over to the Smoker's Vapor at the other end of the plaza and went into the establishment, threatened to tow the vehicles that were parked in his spot. The way I understand the incident occurred, Ms. Voccio, the petitioner therein, was in the back room, and she was summoned out by some emergency word to come out and see what's going on. My client left the establishment. Ms. Voccio ran after him, ran outside, and basically stopped him and accosted him and asked him, "Are you threatening me?" And she re-engaged my client, and apparently my client said, "That's okay, you're not going to be around." The background on that was that the manager had chosen not to renew the lease of the Smoker's Vapor, the electronic cigarette place, And my client had made that statement thinking that this is all going to come to an end because they're going to be gone, which they are gone, but that's besides the point.
Let me stop you, Joe, at the
Pardon?
let me stop you just for a moment on the besides the point. If this was a 6-month injunction.
Yes.
And so if it's over and she's gone, is this moot?
No, it is not moot, because just before the expiration, just before the 6-month expiration of the injunction, the petitioner herein went down to the court and filed an affidavit indicating that there was a violation of the injunction and she wanted an extension of the injunction. Judge Hellinger, Jack Hellinger down in Pinellas, he indicated and stated that, and I believe I filed this in the court file, in your court file.
I know there was a question earlier about mootness.
Right. He indicated that he referred it to the state attorney for the state attorney to make a determination as to whether or not there's going to be charges filed. And as this court knows, I mean, the state attorney can come along any time and file this. So that makes it not moot.
Okay.
Also, I mean, as an
The
aside,
injunction was not extended or from a civil standpoint, at least it hasn't continued on.
correct.
Okay.
It ended, it naturally expired, and it wasn't extended at all. And subsequently, they moved, so there's been no movement there, not movement, but there's been no actions pending since then. There's been no contact, I don't believe, between the parties. The incident that occurred on the 19th that they relied upon saying that my client threatened them, I remember at the hearing, when we started the hearing, the court, Judge Amy Williams below, she started the hearing because she was concerned with her time being expended. I remember John Trevina, counsel here today, was representing Ms. Voccio, and Ms. Voccio was there, everybody was there but Mr. Trevina. He wasn't there, and his office called, said that he's stuck, he's on the bridge. I guess he had a flat tire or engine problems or something like that. And the court started without Mr. Trevina being there. I mean, she had very big concerns with her time being wasted. As the case went on, I was presenting the witness, the manager of the complex. I remember I was presenting the manager's testimony, and the court stopped me. And before I could present his testimony indicating that the lease wasn't going to be renewed and they weren't going to be there, which would justify my client's statement with regard to you won't be around, the court stopped me and essentially ruled. I mean, she had a lot of concerns with the utilization of police resources as well as her own time being wasted. She was of the mindset that she wanted to keep the peace. And that's part of the argument that I argued in my brief, that she was looking to maintain the peace and keep the peace between the parties.
I've seen there was a motion for rehearing, I think, in this case. Was there not?
I believe so. There was a
Was there
motion.
any hearing on that, or was this resolved without a hearing?
Denied, just like that.
Okay.
Denied without,
The indication as to the appellee here moving out, lease not being renewed, and you've made a little bit of argument concerning that. Was that ever put on the record before the trial court?
I don't know if it was put on the record or not. I'm not sure if the extent of the lease was on the record. You have to forgive me. There was a subsequent hearing with another petitioner that was involved with this that I just cannot remember if in fact it was put on the hearing in this or in that one.
My recollection from the briefing is what you said a moment ago, that the judge cut off the presentation of the respondent's case, the appellant's case. And so it didn't seem to me that it had ever come out what exactly was going on with the lease situation.
I know it was cut off. I know what didn't come out.
So if it
Probably
didn't
here.
come out, that's really not helpful to your position.
It's not helpful to my position because it's not on the record. You're right.
Okay.
I didn't have an opportunity. I did, in fact, argue to the court during my argument that I wanted to present more on that, but I was disallowed from doing that.
So the record will show that you wanted to present more and you were not allowed to?
I was not allowed.
Okay.
I mean, looking at the ruling, when I was in the back here and I was listening to the other arguments, I sat here and I looked at the transcript. I looked at it again, probably for the 20th time. And the thing that jumped out at me was the court's ruling. I mean, on page 51, I'm not sure what page on the record it is, but it's page 51 of the amended transcript. The court said, and I argued that this is just a spat between the two parties, that's a property dispute, and the court said they're definitely spatting. I mean, today these two businesses have the entirety of the 9 o'clock calendar, which shows that she was concerned with her time being expended on this on this particular case, as well as the other ones that were brought. And
Remind me, there seemed to be a group from the smoke shop who sought injunctions.
yes, there were, I think, 9 or 10 injunctions that were sought against my client, and then another 9 or 10, however many there were, I don't remember.
I can't tell whether they're all heard seriatim at this one hearing.
I think some of them were heard before I even got into the courtroom.
Okay.
And I know another couple were heard after I got in the courtroom.
Were they all against your client?
No, 9 were against my client, 9 were against my client's son, who also works in the smoke.
I'm almost afraid to ask, but do we have more appeals?
No, there's no more appeals on this. No, I would have moved to consolidate them because I don't want to keep coming back. I mean, I'm sure you guys don't want to hear it either.
We could put it
a
on our
number of
9 o'clock
times.
docket, yeah.
It's like, no, they were denied or dropped or whatever. There was another one that took place months later. I'm not sure of the timing. I think it was January, I think. Was that right, John? January, I think it was. This one occurred in June by the owner of the smoker's vapor that wound up seeking the same kind of relief before a different judge, and Jack Hellinger just denied it. But no, I mean, there's no more coming. Looking at the ruling, though, I mean...
One factual question I have. The judge focuses very heavily on the statements that were made in the parking lot on the first day.
Yes.
And then the judge says, if I was called a fucking bitch and if I was threatened, don't worry about it, you're not going to be here. Was there any evidence that your client called her any names the second day? Remind me of factually what happened. Because he goes in there, he's yelling apparently about the parking situation.
Right.
She comes out, he's leaving the store, she goes out after him, they're engaging. What is said at that time? You're not going to be here, I remember that part. But was he cursing? Was he making sexual comments that time?
There was no sexual comments. There might have been cursing. But I know there were no sexual comments made at that point in time. I would have to review the transcript and go through that.
Because as I read this, it seemed to me the judge was heavily influenced by what happened in the parking lot the first day. And yet there's no testimony that your client was yelling any of those things. It seems unclear. Maybe it's a fair inference that he was instigating, but there's no clear evidence of that.
There is no evidence that my client said anything on the first day. I specifically went into cross-examination on that, and you're right about the record, that it's not on the record. As a matter of fact, looking at page 52, when the court was talking about, she's disgusted, this behavior is despicable, I forgot to mention that she was called something, that's like line 20. I argued at that point in time, Judge, that's not attributable to my client. I mean, I don't understand how you can sit here and do that, meaning issue an injunction when it's not attributable to my client. And then she says, I'm not attributing it to your client. And then I says, then how can you, well, I said, so you're just going to issue an injunction against my client for something he didn't do? And she says, I ruled. And that was the end of it.
Okay.
I was just, flabbergasted is a good word. I just couldn't understand that happened that way.
Why don't we save the rest of your time for rebuttal here?
Pardon?
Why don't we save the rest of your time for rebuttal here? So,
Okay.
Okay, thanks. Mr. Trevina?
May it please the court, counsel. My first point would be, again, with due respect, I know counsel disagrees, but I believe the issue is moot. This is no different than a driver's license situation that this court commonly sees where someone's appealing a suspension because of a DUI and it makes its way up to the appellate court. If the suspension has expired by the time it reaches you, you have previously ruled in other cases that that issue is moot. I don't see how the fact that the petitioner requested an extension, which was denied.
I guess the thing that troubles me, in addition to what he's described, is that a petition on, stalking violence becomes this public record document, and so had an injunction entered against them as a stalker, and you end up with sort of a character issue that doesn't go away when the order goes away.
And I would suggest that the same thing applies when someone's license is suspended. You were driving on you had a suspension on your driving record, and that might impact your insurance. That might have collateral consequences. Someone might look at that and think poorly of you for having a suspension for being DUI. It doesn't change the fact that if the suspension expires prior to the appeal, then it's a moot point. And that's exactly what we have here. We have a situation where this expired nearly a year ago, November of 2013. It's done. So we would respectfully argue, as appellee, that there is no remaining issue for this court to determine. It's an expired injunction. Whatever collateral consequences that may have on his record won't change by this court, even if this court invalidates the injunction and sets it aside. What real effect is that going to have? It still is going to be in the court system. It'll still be in the file. Nothing will change in that respect, and it's completely analogous, in my mind, to the driving while license suspended situations that you more commonly see. With that being said, we believe that there is competent and substantial evidence to support the judge's finding. Yes, the judge was admittedly concerned about the docket and the length of time that these cases were taking on her docket. No question about it. It's reflected by her comments in the transcript. But nevertheless, there was a clear comment made by Mr. Smith's client that can't be ignored when he said to my client, "Don't worry about anything, you won't be around." While I understand counsel's argument that his intention by that was that we'll have you evicted or you'll be removed or you won't longer be a tenant here, whatever his intention, is irrelevant. The reasonable person standard is what has to be looked at.
Remind me if I'm wrong, I still need a couple of incidents, right? And help me understand why I don't have a big gap with the parking lot incident.
Well, while it's absolutely correct that my client was candid with the first incident the day previous and could not identify Mr. Smith's client as being the person who actually spoke the insulting and obscene words to her, he clearly was in the group. He was participating by his presence. He was physically there. He didn't ask anyone to stop. He didn't ask anyone to go back into their offices. This is a complex that's set up. There were like bookends. Mr. Smith's clients, the appellant's on one far end, my client's on the opposite end. There's space in between 4 or 5 businesses, as Mr. Smith said, in between their business. So the idea that, and I think this is probably the undercurrent to the whole petition from my client's perspective, was that the idea that there's a complaint about parking is just frivolous. You'll see the cross-examination questions about the sexual orientation of my client or the business owner with respect to my client. She was a very advocate of civil rights, would prominently display that she was indeed gay, a lesbian, and they felt that that's what was really driving this, that the harassment was based on sexual orientation, not about parking spaces. And I went through...
Let's say that's true. For the first incident on the day where the folks are gathered under the tree, wouldn't there need to be some evidence that he instigated the yelling and screaming and cursing and sexual comments?
I don't think you have to have him directly making.
I'm willing to assume, for the sake of argument, that he was there with these folks complaining about her clients are using his parking spaces, and he might have used some choice words to refer to her, describe her. And then these other people decide to start yelling out those things. The problem is we don't know that. We don't know that he instigated them. And I'm a little concerned that we're inferring a whole lot of things for which there's really no evidentiary foundation.
If that was standing alone, I would absolutely agree. I don't dispute any of what you said.
And on the next day, is there evidence that he's using similar terms towards her?
On the second day, he actually goes into the business, and he uses some very, very choice words when he enters the business.
Directed towards whom?
Directed towards Ms. Voccio.
But she's not in the room.
Well, she comes out, and when she comes out, he calls her an effing bitch, uses the C word. That's on the second incident.
So those are really rude, really impolite, but is that criminal assault?
When coupled with...
The violence has to be two acts that are basically criminal assaults. You may have to prove it by a civil standard, but these are criminal offenses we're talking about.
Right. And when coupled with the don't worry about anything, you won't be around, the totality of that is sufficient in the appellee's argument to sustain the court's ruling. If you look at it too, from the perspective, there's no requirement as to the continuity of the acts that they have to be spread apart in any certain time frame, and we pointed that out in our response. It can be a very short time frame. So even if you disregard the first day entirely and say that because there's no direct testimony that he participated with his own voice in that event, if you look solely at the second day and bifurcate when he comes in, he turns around, then he turns back, and I understand there was a factual dispute as to whether she was the one that actually followed him to re-engage him. Regardless, the court determined, based upon the credibility of the witnesses, that there was sufficient evidence based upon that.
The trial court found that there were two incidents on the second day?
She didn't specify in terms of the number of incidents or the timing of the incidents. As Mr. Smith said, she basically ruled without really any great detail other than saying, if I was called an effing bitch, and if I was threatened, don't worry about it, you're not going to be here. And if I heard the other business telling me to come and sit on your face with your fine P word, not only am I disgusted, I'd be intimidated too. That was the explanation of her ruling. And nothing really more than that, as I recall.
Videotapes may show this, but is there a big discrepancy, a big difference in physical size with these two people?
The gentleman that Mr. Smith represents is somewhat larger than average. He looks, for lack of a better term, more like a biker type. It's a motorcycle type appearance. And she's fairly petite, as I recall. There's nothing in the video that shows any particularly threatening behavior. I mean, some finger pointing, things like that, but no, fists or anything like that. So as I recall, it's really the words more so than any physical gestures other than the finger pointing. But again, I think that the most worrisome for the court, the trial court, and the most worrisome for us when we were arguing it, is this idea, don't worry, you won't be around anymore. We view that as a very direct threat. And I understand the explanation from counsel, but nevertheless, that wasn't provided to her.
It's even without that explanation, it's ambiguous. It is not a threat to kill, it's not a threat to beat up. I'm not actually sure what it is, other than you're not going to be around anymore. If he would have said, this isn't going to be my problem anymore because you're gone, maybe that'd be a little more to his client's favor. But I'm having some trouble with the idea that that's a threat to do her bodily harm?
Well, based on the totality of the testimony, the trial court felt it was sufficient. And clearly, my client testified that she was intimidated by it and she was in fear by it.
Did she testify that she had a fear that violence was imminent?
No. But again, that's not, of course, a requirement for a stalking injunction, imminent violence.
Is this a stalking injunction?
Yes.
Or a violence injunction?
Stalking.
Because the order itself doesn't have any box checked at all, by the way, so.
It's my understanding is this was a stalking injunction, and that's how it's referred to in the transcript. If I'm incorrect, I apologize, but as I recall, that's how it's referred to. And of course, that's how we've briefed it and argued it as a stalking injunction. I would agree that there's no clear threat of imminent violence based upon his actions that day. But again, going to the totality of the circumstances, there's this walks away, comes back, and then there's the comment at the very end where he says, according to my client, I'm tired of your shit, I'm tired of all of your customers parking in my parking spots. So there's kind of a conclusory that he's reached his limit, kind of, again, putting fear into the petitioner that, he's tired of it. She was clearly worried that there would be some future potential acts as a result. And that's all I have.
Okay, thank you.
Thank you.
Mr. Smith?
Yes, there's a couple of things that Mr. Trevino talked about that I need to stress on. When Mr. Trevino indicated, even if you disregard the first incident, and it's clear on the record, it's 2 incidents, okay? Even if you disregard the first incident, well, if Mr. Trevino wants to admit that and concede that, then the injunction fails. You need 2 incidents, okay? 2 separate incidents. Now, listening to what Mr. Trevino said, okay, well, you got the same incident, or the 2 incidents on one day, that you could sever it. Not true, not under the law. I mean, I put this in my reply brief, the second to last page. The civil injunction cases require more than 1 incident, and 2 incidents in one day, not separated by time and distance, is it considered 1 incident and has been found to be insufficient to support a civil injunction. Darrow versus Michella, 805 Southern 2nd, 1068, 4th DCA 2002. Also, multiple acts stemming from a single violent incident do not constitute repeat violence under section 784.046, where those acts were not separated by time or distance, and that's Gazilovsky versus Ben Shamal, 979 Southern 2nd, 1179, 3rd DCA 2008. I mean, if he wants to concede that there was only 1 incident, fine. This court has to rule that this injunction should be vacated and dismissed. One of the things that I did want to point out is that we have a standard of review of a reasonable person in a stalking injunction. The reasonable person, would a reasonable person think when somebody's walking into a store that somebody from the next door, somebody is saying, all these things, would that cause a reasonable person, substantial emotional distress? And my argument is, no, it's not. But my other argument is, even if my client was standing there, and even if, as Judge Silberman said, he instigated this, okay, there's no vicarious liability here. The Power versus Boyle case that I cited in my brief indicated that there is no vicarious liability, and that's the one where a person bought a house and they had a problem, and she was walking by and she was writing things on the mail and sending it to the petitioner, and another person, Fulford, I believe his name was, went and cut the bushes or did something like that, and they wanted to attribute that act of cutting the bushes against that petitioner, and they couldn't do it. But what I think is probably the most telling thing is Judge Silberman would know this, probably best out of anybody in this room, because he wrote the opinion on Polanco versus Cordero back in, I think it was 2010. I would have to look at the citation. But this case is just like Polanco versus Cordero. in Polanco versus Cordero, 67 Southern 3rd, 1235, which is 2010, there was a statement in there that said, "I will get you back." Okay, and that was found to be insufficient, even coupled with failing to stop third parties from respecting the plaintiff therein. Mr. Trevina indicated that my client didn't stop these guys from saying, you know, "You're so fine," and all these other things on the first day, because he didn't stop them just because he was sitting right there is Polanco versus Cordero all over again. I mean, that case has been, when you consider Mr. Trevina's argument, this case squarely falls right within Polanco versus Cordero. There's no vicarious liability pursuant to Polanco, and as far as Powers versus Boyle, and I would ask that this be reversed and remanded and to be dismissed, because I don't believe there's two acts of violence here.
Thank you very
Thank
much.
you.